really quick to the judge, though.
Be some type of a plea. So if, and Mr. Wheeler, it's very nice to see you back.
Thank you, Judge.
We're happy you're doing well. So you all, I'm going to leave it up to you to let me know what's going on, because apparently I'm the last to know here.
We're in the same boat.
Mr. Wheeler.
The defense is requesting that the court sit these matters down for a change of plea on Wednesday of next week when lead counsel for the Parkland case can be here. She's currently out of state and she filed a notice of unavailability this week. But it's our intent to enter a change of plea as to both cases to all charges.
Okay, I have no problem setting the lead homicide case on Wednesday for a change of plea as long as the state is available on Wednesday. However, I have 109 members of the community that are coming back on Monday morning at 8:30, and or actually 55 and then 55 at 1. I don't want to bring those individuals back and inconvenience them if in fact we don't need to do that. So if Mr. Cruz wants to plead on the attempted aggravated battery case, that needs to be done today, because as we all know, people change their minds. I'm not going to excuse those jurors until the case is pled, and I don't want to have them come back if that's the intention. So that case needs to be pled today, whether it be this morning or this afternoon. The other matter, I don't have a problem waiting for lead counsel.
Judge, it's up to the court what the court wants to do. Obviously, the court has to accept the defendant's guilty plea. I think that if the court feels that it doesn't want to inconvenience the members of the community, I understand that completely. I would ask that it be, rolled to Monday. If the court wants to do that, I would ask that my client be dressed out for court for the change of plea as to any case, either the Parkland case or the Beltran case.
Well, it's only 20 to 11 now. So what if the sheriff's office, if I were to ask them and they would agree to put him, to dress him in his trial clothes, and we can come back at 1 and do it? Because I can't, even if it's only 55 people, that's 55 people that have to drive all the way, find parking, pay for parking. I really don't want to do that unless it's necessary. And again, folks often change their mind. Not that your client will or won't, I don't know, but that happens where somebody changes their mind, and that's why I don't want to excuse them until I've taken the plea. I find, I accept the plea and it's all set, we have the paperwork, and I make the requisite findings.
Judge, I have the paperwork in hand if that ameliorates the court's mind at all.
But he can, until I go through a colloquy with him, he could change his mind, and again, because we have already started the trial on that case, I want to do that today. I'm sure that I can arrange to have him dressed.
And Judge, just so that we're clear, we're asking the court to impose a sentence on Wednesday on the counts 18 through 34 in the Parkland case to 17 consecutive life sentences.
Well, we don't have to. I think that's premature as far as discussing that. I first need to take his plea, and it needs to be on the case that we've started the trial on, and then I'll schedule the plea on the other case. But for today, may I see?
We have Captain Carter in the back there. Sorry to call you out, sir.
May I see you for a moment, sir? Thank you. I don't want to embarrass him. Sir, you can come on up. Huh? Yes, please. I don't. One second, they're getting me a mask. I must have brought it outside.
All right, you were just listening in right now to the status hearing, and we'll explain to you what's going on right now. So the defense has said that Cruz plans to plead guilty to those charges regarding the MSD shooting. Now, here's what's going on, though. He also plans to plead guilty for that aggravated battery case involving a Broward jail guard. The problem is that case is set to start trial next week. So right now it seems like they're trying to figure out how to get Cruz in court right now to plead guilty to that case.
Exactly, and that's why she's speaking to that BSO representative. They want to make sure that he is dressed in his trial clothing and is able to come to court this afternoon, not to plead guilty to the MSD situation and the 17 charges against him there, but also instead to look at this aggravated battery case, because The judge has said numerous times that she doesn't want to inconvenience those potential jurors who would be coming in on Monday.
All right, let's listen in.
And then I can give you all time to go over the stuff with him if you need to, and I can put the white noise on, take a recess, let you do that, and then I'll accept his plea.
Judge, the state would raise the issue of competency only as far as I've been advised that the defendant has been evaluated for competency and has been found to be competent as recently as this morning. And we want to make sure that part of the plea colloquy addresses that.
Well, I always ask people whether or not they've been diagnosed with a physical or mental illness, what it is, whether they're taking medication. That's part of my standard colloquy.
Judge, I have no issues as to my client's competency at this time.
Okay.
And it hasn't been raised in this case, but since I know that he was evaluated this morning, I just feel
Sure,
like it needs
I
to be
always
placed
go
on the
over
record.
that. That is part of my standard plea. All the lawyers in here know, I think, Mr. Wheeler, you would be familiar with my plea. And I go over that in depth to make sure that the person can make a knowing, voluntary, and intelligent waiver of all of their rights. So,
Thank you.
okay, so we'll be in recess for 15 minutes. The sheriff's office is going to bring him up, and then Mr. Wheeler and Mr. Ehrman, however long you need to speak to him, you can let me know, and then I'll accept the plea. Okay? Thank you.
And you see there that they are standing in recess. They're going to be bringing Nikolas Cruz to the defense team so that they can discuss what will happen in court moving forward. I think this might be a good time to bring in Cristina Vasquez. She is standing by right now because she's been watching this along with us at the courthouse in Fort Lauderdale. Yeah. Cristina, what can you tell us? I know you're standing there sitting and watching all of this with a defense attorney. Can you kind of put this in perspective for us, what's happening?
Yes, and I'm joining you live from an adjacent courtroom. Let me unpack this for you a little bit. So remember, there are two cases. There is the Parkland shooting death penalty trial case, right? And then there was the battery on a law enforcement officer. It's a second-degree felony case. That relates to that 2018 caught on camera BSO jail guard attack. It was on surveillance video, and it happened about 9 months after the Parkland shooting. If you recall, heading into today, looking ahead, Monday was supposed to be the start of final jury selection for that second-degree felony case with trial testimony expected on Tuesday. And then as of this morning, what happened was the defense team for Nikolas Cruz comes in here for this status hearing and essentially is saying to the judge that when it comes to the Parkland shooting case, they are intending to want to plead guilty to all of the charges in that indictment. She stops him right there and says, but first, let's talk about this battery on a law enforcement officer case because we have potential jurors already scheduled to arrive on Monday. So where we just left them is she asked BSO if Nikolas Cruz could get his trial clothes on and get in here so that they can first address that matter. So now joining us is Mark Eiglarsh. He is a criminal defense attorney and former Miami-Dade prosecutor. Before we get to the Parkland, let's just again, so in 15 minutes, we're going to see Nikolas Cruz. They're going to once again address competency, right? We heard a little bit about that to make sure that he is prepared to plead to the battery case.
That's correct. The first thing the judge has to do is make sure that his decision to plead guilty is knowingly, intelligently, and voluntarily made. If he's not competent, she cannot go forward. But we did hear, apparently there was an evaluation done as recent as this morning, and it looks like it's a green light go.
Okay, now let's get to what we anticipate now could be happening on Wednesday of next week. This is years of conversation on this. And so what the defense is essentially saying is they are pleading to the judge. There was so much time where they were trying to work, right, in a plea arrangement with the state saying he'll plead to everything if you take death off the table. Right. The state has rejected that. And now we see this change in tactic where they're just going right to the judge, which then would trigger in a death penalty case, correct? What would be, at that point, the second phase, the penalty phase. So unpacking that and explaining why make this decision.
Okay, so the public defenders who are representing Cruz are doing this for one reason only, because they believe it's in Cruz's best interest. They wouldn't do it otherwise. They believe then that it increases the chances that he would get life as opposed to death. There's arguments that they could make in the second phase, in the penalty phase. They could say, look, he accepted responsibility for what he did. We didn't put you through a long trial. They also, candidly, are trying to minimize the amount of gore and details evidencing the abhorrent nature of this offense, and that works to their benefit.
And unlike a sentencing hearing, which maybe you might be more familiar with, when it comes to a death penalty trial, when you get to a penalty phase, this is run like a mini trial. They're going to be talking and presenting evidence. They'll be speaking about the character of Nikolas Cruz. Can you explain a little bit about the kinds of evidence you're going to see?
Yes, it's similar to a trial in that there'll be opening statements and the rules of evidence apply, but it's very different in that the sole determination that the 12 jurors will make is whether he should live or die. And I'm doing this with my hands because I'm showing like a scale. The prosecution will give their aggravators, as what it's called, the reasons why he should die, and then the defense will present mitigators, reasons why he should live. And the jurors go back and they weigh that, and they must come up with a unanimous decision. If all 12 say he should die, he dies. If one of them says he should live, and that's their determination, he lives. It must be 12-0 in favor of death for him to get the ultimate sanction of death penalty.
And so therefore, do you think that maybe one of the reasons underpinning this defense idea here is to mitigate against the amount of harrowing testimony that the same 12-member jury would be exposed to if they went through both phases?
Absolutely. There's no question this is a strategic decision. The first ideal scenario didn't work. State, we're willing to plead guilty. Please waive the death penalty. Please, please, please. The state has made it clear they're not going to do it. So the next best thing is let's waive this argument that he's innocent or that he's mentally ill, because that's not going to likely work. They know it won't. So let's go right to the penalty phase. And every time the state puts another gory photo in front of them, they could say, look, we've already pled guilty. We're not denying this was an abhorrent offense. We just believe that there's reasons why you should spare his life.
Also, then, it's interesting. I wonder if part of this is the defense team, in a way, in the court of public opinion, working to flip the script. Because if they come here on Wednesday and say, look, court judge, pleading guilty to everything, life, are they then also sort of telegraphing, perhaps, state prosecution, do you really want to put the community through this and go to a penalty phase?
Yes, I'm confident that the defense is not giving up the hope, albeit a very slim hope, that the state somehow would change their position and just say, okay, you know what, we'll waive the death penalty.
Do you think that's likely?
Very unlikely. In fact, I think the possibility is so low and remote, it approaches almost no real value.
I'm also curious about your thoughts on, and you all might remember just last week when we were covering what was the initial jury selection process for the upcoming battery on a law enforcement officer case. Cruz and the defense team spent 2 days hearing panel after panel, groups of potential jurors say they could not be fair and impartial. Cruz and the defense team watched some of those jurors cry at the sight of them. We did see Cruz on that one of those days just break down a little bit, distressed, as he bore witness, I think, to the impact on community. How much do you think all of that maybe have weighed into this decision today?
I think it's a great point. I think that that's significant. You know, as trial lawyers, we dream of getting a fair trial. And then the minute you get in here and you hear what the jurors are saying, you go, my goodness, I don't know that I'm going to get a fair trial. And so there's so much prejudice here that I think that the defense lawyers feared that, you know, this could be really problematic if we try to argue that he's not guilty by reason of insanity or argue that he's not guilty for some other reason. They knew that that was not going to happen.
So let's say we do get to a penalty phase of the death penalty case when it relates to the charges in the indictment for the Parkland shooting. And the defense team already knows that it is going to be a challenge to find a fair and impartial jury. And now you're talking about the highest stakes of that conversation, and you need 12 of them instead of 6.
Correct.
What are your thoughts on how many jurors they would have to bring in as a pool to really get to that number and the difficulty of that?
Oh, my goodness, a lot. A lot. First of all, if somebody can't inherently be fair, they're gone for what we call cause. There's going to be tons of people who don't want to be here, COVID, they're saturated with the media on this case and they do not feel that they could be fundamentally fair on a case like this, then there's many people who don't want to be here and decide whether somebody should live or die. I think that whatever number they think that they need, they should triple it.
Thank you so much for joining us. And Christy and Janice, I'm going to toss it back to you because I think they're going to be getting going here in just a few minutes.
Oh, all right, Christina, thank you for that. And of course, we're going to continue to monitor this. They right now are taking a 15-minute recess inside the courtroom. And
we're going to go ahead and take a quick break, and we will come right back and bring you right back into the courtroom for more of what is happening here with Nikolas Cruz in just a few minutes.
FHIA Remodeling is looking for homeowners who want to save big. That's right, you'll save big during our window blowout sale. Call right now and get $1,000 off a house full of windows or a new roofing system. Ask about 180 months financing with 0 down and senior and military discounts. Plus, act now and get a $100 gift card with free in-home estimate. Don't wait. It's FHIA Remodeling's window blowout sale. Just call 877-828-FHIA. Call now and save big.
The past year has created so much change in our lives. For many, it also provided the painful reminder of how fragile life is. For over 60 years, Vista Memorial Gardens has offered pre-need plans that have helped alleviate the emotional and financial burden on families during their time of loss. To help those in need, we are continuing to offer our pre-need plans at special rates. For more information, please call Vista Memorial Gardens at 305-821-1421.
MMM is the Medicare Advantage plan that offers more of what you need, like free wellness activity services and much more. Call MMM, Medicare and much more today. 844-212-9859. MMM is the Medicare Advantage plan that offers more of what you need, like up to $1,260 for OTC delivered directly to your home and much more. Call MMM, Medicare and much more today. 844-212-9859.
All right, we're going back to that breaking news at the Broward County Courthouse. You can see right there, Nikolas Cruz has arrived in court. We are expecting him to plead guilty to that case, that aggravated battery charge that has to do with a brawl that took place in 2018 at the Broward County Jail with a Broward jail guard. He's going to plead guilty to that today, but Christy, we know there's going to be a lot of movement next week as well.
That's right. On Wednesday, he's expected to plead guilty to the Parkland shooting massacre that happened. But the reason that we are moving up this status hearing and doing the plea for the aggravated battery today is that that trial was supposed to start on Monday, and a pool of jurors were going to be arriving on Monday, and the judge said she did not want to inconvenience them if indeed there was going to be no trial on that. But she said it was premature to talk about the MSD shooting until we got this cleared off the docket.
Right, and actually, as we're looking live right now, a lot of stuff has happened in really the last 30 minutes, as Cruz was not originally in court, but the judge said he needed to be in court today to make this plea in that case involving the Broward County Jail guard. So he was dressed for court. He is now in court talking to his attorneys right now. The state attorney's office brought up some questions to make sure that there isn't going to be an issue in terms of competency, but that shouldn't be an issue because they said he was evaluated this morning and they are expecting him to go through with this plea.
And Christina Vasquez is also standing by. She's watching this along with us. And Christina, it was so interesting that the judge said that she was basically blindsided by this, that she actually said she was the last to know what was happening here. I know you're sitting there with a defense attorney. Is that unusual?
And that is a great question, and we did hear that, right? She almost felt like, I think she said, I'm the last to know, so felt like many community members as well with this sudden move in this, what was supposed to be a status hearing that was scheduled this morning. As you mentioned, Nikolas Cruz just returning, getting into the courtroom in his trial clothes per court order. There's 3 sets of trial clothes that he has for any pending related trials. Joining us again is Mark Eiglar. She's a criminal defense attorney and former Miami-Dade prosecutor. And does it surprise you that the judge seems surprised?
About taking a plea today, that they're no, I think that she probably knows what's going on. She doesn't live under a rock. She knows that this was working, this was going to happen for some time, I think.
And you really saw her try to ensure that this moment, when it comes to the battery on a law enforcement case, happens today. She really spoke to, well, we don't want to impose any difficulties on members of our community, potential jurors, to come in if they don't need to. At first saying maybe we could do it at 1, they were able to move that up. But you saw her say, let's get BSO here. Can we get him in his trial clothes?
It's the right decision. Serving on a jury is one of the highest honors you can perform other than serving in the military. These people stop their lives. They come here to be of service. There's no reason to make them come in if there's going to be a plea.
Now, as we were watching live, you and I, that moment where you see Maria Schneider, she's the prosecutor, speaking to the judge and saying, asking about the competency, making sure it's on record that there was a moment this morning. But I could see you a little antsy. There was something else that you thought she should press the judge on.
Well, she didn't tell the judge specifically what questions that the judge should ask beyond the generic ones that a judge in every case asks to determine whether somebody is freely and voluntarily giving up their rights and whether they're competent. So she, if she wanted more, that was the time to say it. Otherwise, it looked like, okay, Judge, I'm satisfied that you will ask the right questions, and we'll let it be.
But further unpack that for us. Is the reason why you think that's so important to have in the record because, to mitigate against any sort of reversible error in the appellate court system?
100%. In the system, we always work as if we have to turn the clock back and make sure that we protect against any arguments that someone will make down the appellate road. So one of the arguments will be, well, he wasn't competent to make this decision. So the state just wants to make sure that he's competent. And I think that the judge will probably ask even the defense, is the defendant, in your opinion, ready to go forward today to get some kind of indication on the record that he's knowingly and intelligently waiving his rights?
So as we move forward with this hearing, as we anticipate what's going to happen is everything we just discussed, that the competency issue will be raised and that there will be a plea on this case. And then what are the next steps from that moment?
Well, I don't believe that she's going to sentence him on the battery case today. She'll wait. Wednesday, then, he'll come in and he's going to do this all over again. Make sure that he's still competent. Make sure that he's knowingly and intelligently giving up his rights, that he knows that it's going to go to a penalty phase and that the sentence will be determined by 12 people from the community. The judge needs to make sure that he's doing this freely and voluntarily, separate from his very fine attorneys who believe this is in his best interest.
And now let's maybe connect the dots a little bit between the impact this case could have on the penalty phase of the upcoming death trial related to Parkland shooting. So one thing we had discussed with our community members last week is about a conviction in this battery on law enforcement case being used as an aggravating factor when it comes to the penalty phase of the upcoming trial. So now, where are we now in that? Because it's not if there's a conviction, if we're in this plea moment.
Yeah, it's something that is not helping his cause. The argument is just let him live. Just let him be in prison. He'll be peaceful, he'll be okay, and the state, I think, will counter that with, well, look how he acts when he's in custody. And so it's not a good factor for the defense.
And then when it comes to aggravating factors, so when you get into the penalty phase and you're going to have a 12-member jury that are making, as you say, this weighing, right, life or death, and that's an incredibly difficult decision.
It is. Yeah, no, it is. In fact, many jurors are excused when they find out, wait, this is what I'm doing? I just thought maybe it'd be a little, marijuana case and I'd say guilty or not guilty. You want me to decide whether he lives or dies? That's an awesome responsibility, and those people should not be forced to sit if they don't feel that they can render a fair verdict.
And we discussed how it's the best way to describe it, I think, is like a mini trial where there's evidence presented, and then you get to the character of the person, which normally wouldn't be something that's discussed.
That's correct. That's correct. Now, normally in a trial, that's really not relevant. We as defense lawyers try to work that in to try to humanize our clients. But this is all about who he is, how he got here, what mental illness he might have, his age. That's from the defense perspective. All the mitigators, the reasons why he should not die. And then the state, of course, will focus on the aggravators, the reasons why this was such an abhorrent offense and why he should get death.
And then when it comes to that moment, you both have the experience of a current criminal defense attorney and a former prosecutor. So I'm curious, as you're picking the jury, right, for this death jury, what are some of the questions you're asking? And first, from your defense hat on, what are the kind of questions you're trying to gauge to find a jury that maybe is on your side and wants life, and then your state hat on the other side?
To me, the number one question, if I had to pick one on the defense side, is, folks, you've heard about this case. You see the grieving families here. If you feel that the mitigators, meaning the reasons why he shouldn't die, outweigh the aggravators, and you're inclined to vote for life, could you do it? Could you look at the families in this courtroom and say, I didn't give you that one thing that you want? because it wasn't the right legal decision? That to me is the number one question I'm asking.
And as we're watching this hearing behind us live, it looks like they have approached the bench. What do you think is the conversation they're having right now?
Well, if it's with the lawyers, I think the judge is making sure, first and foremost, that they believe that this is what he wants to do, that he's competent today. There's been no evidence that he is not ready for this task. And I think that's probably the primary discussion.
In what you've been saying, you've sort of articulated a viewpoint trying to help folks understand maybe the strategy that is underpinning what we're seeing develop this morning. But from your opinion, is it sound? Is it practical? Is it wise?
I have full faith in Cruz's attorneys. He comes from a great office here in Broward County. They do great work. They don't want to see him die, you know? So they're doing everything in their power to make that happen. And they're definitely mitigators. There are reasons that the jurors should consider. And I believe that they're doing this in his best interest and believe strategically it's the way to go.
And then with your state perspective hat on, when it comes to the aggravating factors, we already spoke about the incident, right, that happened at the in 2008, caught on camera, this BSO jail guard attack video. Why?
Doesn't help. Yeah, that fact doesn't help. And then the crime itself, which the public defenders will readily admit was an abhorrent offense. They can't get around it. You don't call it anything other than that. But again, the focus then is on, should he live or should he die? He already pled guilty, folks, will be the argument. And then they'll talk about his age and his alleged mental illness. You know, all that will need to be presented and proven to this jury, and they'll decide.
Thank you so much. And Christy and Janice, I'll then toss it back to you, as the two of us will also be monitoring the developments that happen in just minutes away.
And Christina, while we still have you, we would like you to relay this question to Mark as well, because we're talking a lot about the defense's side and what sort of their game plan is going to be in all of this. But we do want to talk about the side of the state here when we talk about the 17 families who lost loved ones to the MSD massacre, but also so many other families who had to deal with the trauma of all of it. Talk to Mark about possible impact statements. Could we expect in the penalty phase to hear from anyone who wants to speak in court in terms of the families of MSD?
Mark, we have one question from you. So Janice and Christy, who are anchoring right now, Janice Fernandez had a question for you in terms of when we get to that penalty phase, you know, the 17 families that lost their loved ones, will we hear from them during that moment?
It's possible. It's very possible that the state will try to call them. Obviously, it's compelling testimony. I mean, that gets you. That's what the state has the best of in terms of evidence. If they can find a way to call them during the penalty phase, for sure they will.
And what do you think the impact of that will be on these jurors that we've already kind of described what this harrowing evidence that they're already going to be exposed to at that point?
I'll answer it this way. I'm a father of 3 children, teenagers, and when I really think about the loss, I want to cry. So I try not to think about it. You put it in front of these jurors and let them feel what they're going through. That's the most compelling evidence that they have.
And again, to bring up last week, I mean, last week really was a moment, right, during this initial jury selection where we heard from these prospective jurors and so many of them articulating that the question was, can you be fair and impartial on the battery on law enforcement case if you knew about what happened in Parkland? And there were so many who said they just couldn't. We also heard from some jurors that said how they knew someone impacted, right? There was one juror, I remember her saying, you know, a church member died in Parkland. And I think it's the first time maybe all of us as a community saw the defense and Cruz really bear witness to how this is reverberated. This is a community, sounds like, trauma all these years later.
You know, to their credit, his lawyers never said anything publicly in any way that offended us, meaning they didn't try to minimize his actions. They didn't try to call it something that it wasn't. They're not disputing that this was an abhorrent act. The only issue is limited to what should happen to him. And in the law, it says death is different. It's reserved for only the rarest, most abhorrent of cases. And maybe this is that one, maybe it's not. And that's why we're going to have a jury decide, you know, does the balance tip in favor of death or life?
And that section we talked, death is different. There's one other legal analyst, when he referenced that, also said that just, you know, when you look at past case law, death penalty cases are hard to hold together often. Why is that? Why is this so much more difficult when it comes to the penalty phase when you're making that argument to a jury?
In every case, you're not talking about life or death. You know, you're talking about first-degree murder here. It's very different than every other case in our system. And death should be reserved for the ultimate and rarest of cases and shouldn't just be handed out because people are angry. That's why we impanel a jury that says that they can be fair and impartial, and they carefully weigh the mitigators and the aggravators. No pitchforks, no one yelling, just calmly analyzing. Certainly they're not robots. They're going to take into account sympathy. They're going to do that. That normally is going to happen. But they have to render a fair verdict under the law, and that's to weigh both sides and make a decision.
And I hear that Janice and Christy Kruger and Janice Fernandez, who are anchoring, they have a question. Back to you guys. What's your question?
Well, Christine, I wanted to follow up on something that Mark said a little bit earlier. He used the term if the prosecution can get it allowed in, that some of these, the victims' families can talk and give a statement. Is it an if, or would that be a given? I mean, usually in a penalty phase, the victims' families do get to speak. Would that be something that might not happen? Because we have spoken to these families time and time again, and I feel quite confident that most of them would like a chance to face that Nikolas Cruz and tell them how much he has taken from them.
Right, how much that impact has been. So they want you to double back a little bit again on this idea of impact family statements. And there was a if, you know, why is it an if? Because there's these families, as Christy Kruger is explaining, as our community knows. I mean, one thing that became a national headline after the shooting is how much even the survivors and then the loved ones of those lost, I mean, they became national advocates, right, for gun legislation reform, and they really had a platform. These are vocal families. So Christy's question is, why the if? Because there's probably going to be a lot of families who lost their loved ones who would want that moment.
I say if because I've been a trial lawyer for 30 years and nothing is definite. Every piece of evidence that either the state or the defense wants to advance could be objected to, and then the judge will have to decide. And generally there's a balance on whether it should come in or not, and so I said if because that's why.
And Christy and Janice, you know, we've done a series of stories, and we've all heard from so many different community members, and sometimes you can hear a divide a little bit about the impact of watching the entire, what would have been the first phase, the guilty phase of this upcoming death penalty trial. You know, there's some that told us they really think that's going to be the moment. They've been waiting for this moment to see justice served. There's other that thought maybe that's too difficult and too painful to live that, and then a mini version of that in the penalty phase. And so as I hear you, Christine, Janice, you know, really thinking about the families from your view for the moment that may happen on Wednesday, right? They're telegraphing that on Wednesday they're going to come in, plead directly to the judge, kind of triggering the start of the penalty phase. What do you think the impact to the families of not having that first moment?
I think that there should be a sense of relief. I mean, that trial would have gone on for a considerable amount of time. It would have been very uncomfortable. They've got the guilt phase taken care of. That's one part. If they're desirous of death, that's one part that's done. They don't have to worry about it. There's not going to be issues on appeal, really. It would just be related to whether he freely and voluntarily gave up his rights. And I know this judge is a fine judge. She's going to go and make sure that that's what he wants to do. But then they've got the second phase. And that one is not a slam dunk at all for either side.
Thank you so much for your time. And Janice and Christy, so again, just to kind of bring everybody up to speed, and I don't know if you've been watching live with us, but we had the lawyers for both sides, right, approaching the bench, and now you see Nikolas Cruz, again, dressed for trial, and he is he's with his team, and so we are still anticipating that within the coming and who knows, right? Exactly how Mark Eigelash just said. You know, when you cover these court hearings, a lot of it sometimes is just being in the moment, and we'll kind of see when it happens. But we do anticipate, based on what the judge has said, that she wants the defense team to do that moment of doing their plea for the battery on the law enforcement case. Again, that's a second-degree felony case related to surveillance video that captured Nikolas Cruz in 2018 rushing and attacking a BSO jail guard. That she wants that moment to happen today, and that is because originally what was on the docket was final jury selection in that case was supposed to be on Monday, if you remember. There was about 106 potential jurors that emerged from the 2 day of initial jury selection selection that were going to be brought back for that 6-member jury. And then trial testimony was supposed to start on Tuesday. And so the judge is articulating, let's be respectful of the community members that are serving their time as potential jurors, and why invite them in if that's moment's not even going to happen. So that's why we anticipate the judge to continue pressing the defense team that if you're going to do this thing, let's go ahead and do this thing today.
Yeah, and Christina, we are watching with you as we're actually speaking to you. We know you're in an adjacent courtroom, and on the screen we have a split screen where we can see what is going on inside as well. We're kind of going back and forth between these two cases, and of course a lot going on right now. But talking about really the case that the trial that was going to happen next week, as you were just saying, for those charges, he was facing a 15-year sentence possibly. That was sort of one of the maximum sentence he could possibly face for what occurred there. From your perspective, Christina, because you have been covering these hearings and everything and the process that has been going on, I know that we've seen some, I guess we could say, interesting behavior, interesting moments in the courtroom, and sort of seeing Cruz's behavior when we were just sort of in these hearings and things like that. You have to imagine that this is a strategy by the defense team, thinking that he probably would not be able to handle a full trial, not only for this case involving the Broward County jail guard, but also the MSD case.
It was clearly a moment, right? So I've seen him in person inside a courtroom. We've seen him in hearings over a course of time, and there was a consistency to his demeanor. On the first day of the initial jury selection, he seemed very engaged, if you remember. He was note-taking, and he was really studying and looking at kind of a grid of the jurors, and just seemed really attentive and engaged in the process. And then that very next day, the second the hearing started, it was, even you could see it was visible, right, on his face and his affect and his demeanor, that he was having a moment. He appeared distressed. He was provided tissues from the defense team. Looked like he was, blowing his nose. And at one point, if you recall, you could kind of see him shaking a little bit. So you heard from Mark Eiglarsh here about, what kind of him opining on what he thinks that impact could have been for Nikolas Cruz and the defense team as they, as he's sort of absorbing what he's hearing from these potential jurors. And if you remember, back then we interviewed another legal analyst, David Bogenschutz. He is also a criminal defense attorney. One thing he said is maybe what you were witnessing there is
okay, Christina, we're so sorry. We're going to have to interrupt you because it looks like something is going on inside the courtroom, so we're going to go ahead and listen in and go back to you shortly.
You all are, of course, welcome to come with him or stay with him. Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Please state your full name for the record.
Nikolas Cruz.
Are you currently under the influence of any alcohol or illegal drugs?
No, ma'am.
Are you taking any medication?
Not at the moment, nope.
Okay, when you say not at the moment, do you mean not today or not in the past month?
I have taken in the past, but nothing recently.
Okay, and by recently, are you talking a week, 2 weeks?
About like probably a year.
Okay, so you haven't taken any medication in a year?
Nope.
All right. Do you suffer from any physical or mental illness?
I was told in the past, but I don't believe I have any issues.
Okay, what did they tell you? You said you were told in the past.
I was told in the past I suffered like anxiety, depression.
Okay. And but no formal diagnosis?
No formal diagnosis.
All right, and how are you feeling today?
Feeling all right.
I understand you're nervous. I assume you're nervous. That's normal. But
Yep.
What I need to know is, are you feeling any type of anxiety to the extent that you would not be able to understand or follow along with me when I'm speaking to you?
No, I understand.
Okay, and you're thinking clearly?
Yes, ma'am.
And you understand me when I'm speaking to you?
Yes, ma'am.
And are you having any trouble communicating with your lawyers?
No, I am not.
Okay, and do either of the attorneys have any reason to believe that Mr. Cruz's competency is compromised this morning?
No, Judge, I don't.
Okay. Sir, how old are you?
I am 23 years old.
And how far did you get in school?
I got to 11th grade.
Do you read and write the English language?
Yes, ma'am.
Have you gone over the charges and the charging document with your lawyers?
Yes, ma'am.
And have you gone over the the plea form with your lawyers?
Yes, ma'am.
And have you read each and every paragraph that's listed in this 2-page plea form?
Yes.
And are these your initials here? Showing.
Sorry, I didn't.
You all can. You want to take it?
Glasses.
I just want to make sure that you are the person that initialed, or perhaps you read it and someone initialed on your behalf.
Yeah, these are my signatures.
Okay, so you initialed each paragraph as you went over it.
Yes, ma'am.
Okay, thank you. Now, sir, also state, did you give me a score sheet?
And the prison. Of course, you have a prison.
Thank you. Thank you. And has the defense had the opportunity to look at the score sheet?
Yes, Judge.
All right. So I'm going to go over your charges with you now. In count 1 of the information, you're charged with attempted aggravated battery on a law enforcement officer. That's a second-degree felony, and it's punishable by a maximum of 15 years Florida State Prison. Do you understand?
Yes.
Count 2, you're charged with battery on a law enforcement officer. A third-degree felony punishable by up to 5 years Florida State Prison. Do you understand?
Yes, ma'am.
Count 4, you're charged by information with depriving an officer means of protection. It's a third-degree felony, and it's punishable by a maximum of 5 years Florida State Prison. Do you understand?
Yes, ma'am.
Count 4 is attempted use of a self-defense weapon against a law enforcement officer. That's a first-degree misdemeanor, and it's punishable by up to a year in the county jail. Do you understand?
Yes, ma'am.
Do you understand each of the charges as well as the maximum possible penalty that can be imposed on each charge?
Yes. Yes, ma'am.
Okay? Sir, under the Florida Criminal Punishment Code, that's your score sheet. With these charges alone, you score 14.40 months Florida State Prison at the bottom of the guidelines. So I have the discretion to sentence you from a period of 14.40 months Florida State Prison up to and including the maximum penalty on each and every charge that I just went over with you. Do you understand?
Yes, ma'am.
Okay, it's also my understanding that this is an open plea to the court today. Is that correct, Mr. Wheeler?
Yes, ma'am.
Which means you are asking, as opposed to negotiating a plea with the state, you are pleading to the court and asking the court to impose what I believe to be a fair and appropriate sentence in this case. Do you understand?
I understand.
Do you understand that I'm not making you any promises or guarantees as to what sentence I will impose at this time?
Yes.
Okay, has anyone made you any promises or guarantees as to what sentence would be imposed if you were to plead open to the court today on these charges?
No, ma'am.
Has anyone threatened or coerced you into entering into this plea?
No, ma'am.
Have you had enough time to speak to your lawyers? And when I say lawyers, that could be Mr. Ehrman, that could be Mr. Wheeler. You have the benefit of having a team of lawyers. So when I say lawyers, I'm speaking individually of them and of them in the collective or as a group. Are you satisfied with their services?
Yes, I am.
Is there anything else that you feel your lawyers need to do on your behalf that they have not already done before you enter into your plea today, sir?
No, ma'am.
Do you understand, sir, that by entering into a plea today, you are waiving several constitutional rights, including the right to require the state to prove each and every allegation against you beyond and to the exclusion of a reasonable doubt? Do you understand?
Yes, ma'am.
You're waiving your right to have a trial in this case. Now, as you know, we have begun jury selection in this case, and as soon as the jury was selected, we finished the selection, which I assume would happen Monday, we would start the trial. And at the trial, the state would have to prove by testimony and evidence each and every allegation and each and every element of each charge against you beyond a reasonable doubt. And if they could not meet their burden of proof, the jury would have to find you not guilty. Do you understand?
Yes, ma'am.
And do you understand that by entering into a plea, you're waiving your right to require the state to prove these charges?
Yes, ma'am.
Do you understand you're giving up the right to have your lawyers confront and cross-examine the state's witnesses who are called to testify against you? Can we? Is there a way we can mute?
You have to mute it on your system, mute all.
How do I do that?
On your Zoom. In Zoom.
It's not coming on the screen. It's on the other screen. Go back to your phone.
Okay, she just muted.
Okay, just keep it. Yeah, but I'm still gonna, I don't wanna mute everybody. You have to click on the little microphone. Don't click on those, they're all muted. This person's not muted. No, that's
That's this one. Good.
no, one minute. All right, sir, do you understand that you're giving up your right to have your lawyers confront and cross-examine the state's witnesses who are called to testify against you?
Yes, ma'am.
Just like your lawyers confronted the state's witnesses at the motion to dismiss, they would again have the opportunity to confront in that type of manner all of the witnesses that would be called to testify against you. Do you understand?
Yes, ma'am.
However, but by entering into a plea, you're giving up that right. Do you
Yes, ma'am.
understand? You're also giving up your right to remain silent and not have that held against you in any way whatsoever. Do you understand?
Yes, ma'am.
If you were to choose not to testify at trial, I would tell the jury that they could not hold that against you under any circumstances. Do you understand?
Yes, I understand.
You're also giving up the right to present testimony and evidence or a defense on your own behalf if you have one. Do you understand?
Yes, ma'am.
Finally, sir, you're giving up the right to appeal the judgment and sentence of the court. Do you understand?
Yes, ma'am.
If you were to take these charges to trial and have a trial in this case, and after trial you were to be found guilty, and either your lawyers or yourself or an appellate lawyer were to believe that either myself or one of the attorneys committed reversible error, you would have grounds to appeal the judgment and conviction. Do you understand?
Yes, ma'am.
Do you understand by entering into the plea you're giving up that right?
Yes.
Do you also understand that if you were to go to trial and you were to be convicted of one or all of the charges or some of the charges, that you would have the right to appeal my ruling on the motion to dismiss, which I denied. But by entering into a plea, you're waiving your right to appeal and take that issue to a higher court. Do you understand?
I understand.
You're giving up your right to appeal any issues that have been decided pre-trial. So any motions that were heard and not ruled upon in your favor could ultimately be appealed if you were to go to trial and you were to be convicted of one or any of the charges. But by entering into a plea, you're giving up that right. Do you understand?
Yeah, I understand.
Okay, do you have any questions about that?
No, ma'am.
In addition, sir, I need to advise you that the state is going to be using this conviction in this case as evidence of an aggravating factor for purposes of arguing in favor of the death penalty. Do you understand that?
Yes, I do, ma'am.
And do you understand that you understand the meaning of an aggravating factor? Is that correct?
Yes, ma'am.
And has the defense counsel gone over the concept of aggravating and mitigating factors with their client so that they are confident that he does understand what they mean and how this judgment here today or conviction will impact him and his homicide trial?
Judge, I've gone over the pros and cons of either trying this case or entering a plea to this case and the impact that would have on the 1958 case.
Okay, and you're confident he understands what I say when I'm explaining to him about an aggravating factor?
Yes, Judge.
Okay, thank you. Okay, excuse me, is the defendant waiving PSI?
Yes, Judge. I've explained that to him also.
Right. Sir, if you are not a U.S. citizen, you will be subject to deportation under the laws and regulations of the Department of Homeland Security upon entering into this plea. Do you understand?
Yes, ma'am.
In addition, sir, if the offense to which you are pleading is determined to be a sexually violent or sexually motivated offense, or if you've been previously convicted of such an offense, this plea may subject you to involuntary commitment upon the completion of your sentence. Do you understand?
Yes, ma'am.
Has the state disclosed all items of physical evidence in discovery, Ms. Schneider?
Yes, we have, Your Honor.
And has the defense reviewed the discovery in this case with your client?
I have, Judge.
And is either the party aware of any physical evidence, if tested, that may exonerate the defendant of the charge or charges in this case?
No, ma'am.
State? You're not aware of any evidence that would exonerate him?
Your Honor, that would exonerate the defendant.
Okay, thank you. All right, Mr. Cruz, at this time, do you have any questions, either for me or for your lawyers? If you need to speak to your lawyers, I'm happy to give you time in private so that you can talk to them. I'm about to ask you how you wish to plea in this matter, and then there won't be any time for questions. So now is the chance. If you have any questions for me or your lawyers, just let me know.
I think I'm good.
Okay, you sure?
Yes, ma'am.
All right. Sir, in case number 18-14129, to count one of the information, attempted aggravated battery on a law enforcement officer with a deadly weapon, how do you wish to plead?
I plead guilty.
Count 2, battery on a law enforcement officer, how do you wish to plead?
Guilty.
Count 3, depriving an officer means of protection, how do you wish to plead?
Guilty.
And count 4, attempted use of self-defense weapon against a law enforcement officer, how do you wish to plead, sir?
Guilty.
Also, are you agreeing that your credit for time served at this point is 1,068 days?
Yes, ma'am.
Okay. I accept your plea of guilty. I find that you are alert and intelligent, that you understand the nature of the charges, that you understand the consequences of entering into the plea. I find that you have made an informed decision with the advice of counsel, and that you're knowingly, voluntarily, and intelligently waiving all of the rights that I just went over. Are the parties stipulating to a factual basis for purposes of the plea in this case?
Yes, Judge.
Your Honor, the state is prepared to prove by competent evidence that on November 13th of 2018, the defendant attacked Sergeant Ray Beltran, who is in the courtroom today. Sergeant Beltran was wearing full BSO gear and was in fact working at the jail, so the defendant was quite aware that he was a law enforcement officer. The defendant proceeded to kick, hit, punch Sergeant Beltran, attempted to remove Sergeant Beltran's electric taser, took that electric taser and attempted to hit Sergeant Beltran with it over the head as if it was a blunt object, and attempted to remove that from his person, thus giving a basis for all of the charges.
Okay, based upon the proffer supplied by the state,
Judge, we would stipulate as the facts as alleged in the PC.
Okay, the stipulation by the defense counsel, as well as my own review of the court file and my review of the video that was presented to me at a court hearing, I do find there's a factual basis for the plea. And
Your Honor, I'm just going to interrupt for a second because for some reason the printout that I gave you of the score sheet did not include the last charge, so I've added it. It makes a little point of difference, but I would ask that we use the corrected score sheet.
did you give Mr. Wheeler a copy?
I will in a second. Let me add the point.
Sure it's not there? The point
No.
two?
It's not seen.
It's this one.
Maybe I did.
Do you have a supplemental page?
No.
The point two? Yeah, there's a point two.
There's a point two, but it wasn't listed, so I've listed it now.
So have you seen the corrected score sheet?
Yeah, I saw it when she handed it to you, Judge. It's fine.
Do you want to take a look at it?
Judge, it appears to be the same calculation. They just left out the charge.
Okay. But the ultimate calculation is by... It looks like he scored what I told him was 14.40 at the bottom, and now it's 14.41.
That's fine.
Okay. Do you understand, Mr. Cruz?
Yeah, I understand.
I advised you that the bottom, what we refer to as the bottom of the guidelines, or the lowest permissible prison sentence under the Florida Criminal Punishment Code, was 14.40 months Florida State Prison. The state inadvertently left off the use of a self-defense weapon, which is a first-degree misdemeanor. When you add that misdemeanor, which is a .2, you come up with the lowest permissible prison sentence in months of 14.41, as opposed to what I told you, 14.40. Do you understand?
Yeah, I understand.
Does that change your decision as to whether to enter into this plea today?
Nope.
Okay. And is Mr. Cruz requesting a PSI?
We are not, Judge.
So you're waiving PSI?
Yes, ma'am.
Okay, and when are you all requesting to set the second case for a plea?
Wednesday, Judge, next week.
And does that date suit the state?
Yeah, that's fine, Your Honor.
So we'll do it Wednesday at 9 a.m.?
That's fine.
And how long do both sides anticipate this taking? Are there going to be, is it going to be anything other than a plea? Are you going to ask me to hear from anyone, Mr. Satz?
No, Your Honor, there's going to be another phase to it. So.
No, I understand, but I just want to make sure. So it should be an hour at the most.
Judge, I mean, we're going to ask the court to sentence him on counts 18 through 34 to 17 consecutive life sentences. So if the state would like to have their victims here to present their testimony, they'd have the opportunity to do so.
I'm not inclined to sentence him until the end of the trial. When I impose the sentence that's recommended by the jury, I would just sentence him at that time. Is there a reason you want him sentenced earlier than that? Because then we have to have testimony and evidence twice. I assume, Mr. Satz, if I were to sentence him on the non-homicide charges that you would want, would you then have people that would want to speak?
I'm sure we would. The victims probably would.
So it seems to me, we can do it all at once.
Well, Judge, the sentencing for counts 1 through 17 obviously is what the penalty phase is going to be for.
I understand.
Realistically, what is the relevance of the counts 18 to 34? The state's seeking to not impose death on those counts, and they can't. But we can cross that bridge on Wednesday, Judge, if you want to do that then.
All right, but just so you know, my inclination is only to accept this plea on Wednesday. Now, for the original purpose that we were here, I asked that we do a status conference for the lawyers on the homicide case so that I could tell you which days I have set aside for pre-selection of jurors.
Judge, I would ask the court to entertain pushing that conversation off into Wednesday also. Ms. McNeil has filed a notice of unavailability for this week, but she will be back on Wednesday.
Okay, it was the whole point of this hearing. I'm confused why we're here if that was the reason why I needed to meet with you all. But I'm just going to say, this is what I'm going to let you know right now. I have had the clerk's office issue summons for jurors November 8th, 9th, 10th, 15, 16, 17, 29, 30, 31.
Judge, can you give me those dates more?
I'm sorry, yes. November 8th, 9th, and 10th. November 15th, 16th, and 17th. November 29th, 30th. And December 1st. Those are all Monday, Tuesday, Wednesdays. As well as December 6th, 7, and 8. And December 13, 14, and 15. I've made arrangements to have extra jurors summoned just for us. And those are the dates that I have set aside. That's 15 days. I think we can get through 250 a day. We'll use Judge Williams' courtroom. We have it all mapped out so that we can have up to 58 people socially distanced in that courtroom. And we can get through, hopefully, the better part of jury selection so that after the first of the year we can start the trial. That's my intention.
Judge, I don't believe we're going to be ready to begin the jury selection on those dates, Judge. I would like Ms. McNeil here as lead counsel for the penalty phase to explain her need for continuance.
Okay, well, I'll consider whatever you ask me to, but that's the plan. Mr. Satz, you wanted to say something?
Yeah, I just wanted to put on the record again, Your Honor, we haven't received any witness list for either the guilt phase or the penalty phase. If it's going to be mental mitigation, we want an opportunity to know who those people are and take their deposition, and if necessary, have our experts.
I understand. I was unequivocal with all the lawyers here, including Ms. McNeil, that this month was going to be set for Mr. Cruz's first trial starting October 4th, and then I set aside the entire week of October 18th and the 25th for all of the pretrial motions in the homicide case, and I was very clear that I intended that the trial was going to start after that. So there shouldn't be any need for any type of continuances. Everyone knew what was happening, and if they haven't been listed, then I don't know what to tell you. Maybe they're not calling any. But we're in recess for now, and I'll see you all Monday at 9 a.m. We're going to do it no, not Monday. You said Wednesday. Wednesday at 9 a.m. in Judge Williams' courtroom, which is what is it, 7840.
You want us in Judge Williams' courtroom for Wednesday's change of plea?
Yes, we already have it all set up. I think there's more room, and it will be more comfortable for everyone. Okay?
So is it the court's inclination to adjudicate and sentence Mr. Cruz now on the Beltran case?
No.
Okay. You want to hold off until Wednesday?
I'm going to defer for now.
Understood.
Thank you.
Your Honor, this is Deanna Shulman on behalf of one of the media coalitions. May I just ask an administrative question about this Wednesday's hearing?
All right, you were just listening in to this status hearing that really became Cruz pleading guilty to 4 different counts regarding that case that happened in 2018 between a Cruz at the Broward County Jail and a Broward jail guard there. So he pleaded guilty to all 4 counts. He was not sentenced for that specific case yet. The judge is going to defer that, but he did plead guilty to those counts. But there's a lot of moving parts here, Christy.
Yes, and so the next time we will see Nikolas Cruz in a courtroom will be next Wednesday. Let's turn things over now to Christina Vasquez. She's been standing by watching this along with us. And so Wednesday will be the date that we will be looking to where he will be pleading guilty to the homicides and the attempted homicides in Parkland.
And that is what the defense team says they intend to do. But let's talk a little bit about what just happened right here. So essentially the judge accepting the Nikolas Cruz's pleading to those 4 counts guilty. And one thing that's interesting, I'm bringing in again, this is Mark Eiglar. She's a former criminal defense attorney. She's a current criminal defense attorney, former Miami-Dade prosecutor.
I still defend him, yes.
Yeah. And one thing that I saw your eyes really open on is you may have heard as she's going through that moment that you had told us, to anticipate, where she's ensuring that, he's competent, he's aware, he's waiving his rights. And when she accepts the plea, she says you seem alert and intelligent, which earlier when she asked Nikolas Cruz, he had said in the past, I have suffered from some anxiety and depression. And then she asked,
okay, so here was my concern. This is why I rolled my eyes. Her saying that he's alert and intelligent, that's standard language in almost every plea. A judge will say that. That's generic. I knew she would say that. What concerned me was when they asked him whether he suffers from any mental illness, his indication was no. So either he doesn't, which is unlikely, or he doesn't know about it, and his his experts will say otherwise. I thought that was an interesting moment.
Okay, and then we talk a little bit about sentencing when it comes to this one. And she kind of walked through there, right? What the max is and minimum is. And then she said, let's pause on that and put them together. Why?
There's something called judicial economy. Why have 2 separate sentencings when you could do it all at the same time? She doesn't want to have different people testify twice. So let's see what happens in the penalty phase. They might give him life, they might give him death, and then at that same proceeding, she could determine what the appropriate sentence is for both cases.
Okay, thank you so much. And again, so the next big upcoming moments will be Wednesday of next week. That is that hearing where, again, we intend to have Nikolas Cruz and his defense team plead guilty to the charges in the indictment when it comes to the Parkland shooting, triggering then what you would see is then the penalty phase of that death penalty trial. And we also heard telegraphed from the judge, she's already set some dates aside, 15 days going from November into December for possible jury selection. Although, as you heard live, it looks like that's going to be a little bit open because the defense team's saying that perhaps they may not be quite ready then. So it's definitely a stay tuned. Back to you guys.
Okay, well, we know that you have a lot to get to there, and we will come back to you again during our noon hour and talk more about what happened in court. But for now, we're going to send it back to The View.
Yep, we'll see you at noon.
I'm Jared Blakely of Blakely Law Firm, and I want to get you money for your car accident injury. Other lawyers are on TV bragging about how big they are. These TV ad lawyers don't even say the word South Florida in their own commercial. Try calling these firms and ask to speak to the lawyer you just saw on TV. If they won't give you the respect of speaking to you directly, why would you want them handling your case? Call 1-800-602-5000 to speak to a car accident injury lawyer that actually answers the phone and will